All right, we're going to be going into part 3 of this basics of criminal law. Last time I had mentioned something, we talked about the idea of the Constitution, Bill of Rights, and I just wanted to point out something I do want to talk with you guys in person about when we do get back to the classroom. We have the idea of, especially with things that are going on here recently, with things that are, that Twitter, Amazon, Apple, and some other, like YouTube, for example, some of the different censoring that is going on. I want to talk to you about how you feel about the idea of, in essence, the First Amendment, where it fits in, whether, where we should draw the line on what sort of limitations we have on First Amendment rights, but also what the limitations of companies or the government should have on what people say. So I will probably remember, but yeah, we definitely need to bring that up whenever we get in the classroom, because I think that'd be a really interesting topic to talk about. But for right now, I want to speed it up a little bit, kind of go through the adversarial justice system that we have. I think most of you are aware, the different sides or different aspects of our justice system. It is adversarial in nature, but there are a lot of times it doesn't necessarily work out to be completely antagonistic. So, like I said, it typically is prosecution versus defense. But as I relayed just a little bit ago, the question is, do we always have this these two opposing sides that are butting heads and never really getting along or working together? And so this would be a good thing to ask in class. However, we don't have the option. So really what it is that in reality, they work together. Both sides tend to work together fairly often. And this can be, as it says here, pre-trial or even during trial or intra-trial. Pre-trial, you work on things like plea bargains, plea agreements. During the case, if something changes, you have both sides have to communicate, even if it's discovery beforehand or even during trial. There's always times where the defense and the prosecution have to communicate. They may not see everything eye to eye. They may change some different things, but for the most part, they do have to cooperate. And sometimes they ultimately want the same purpose or see the best end to the overall case or situation. So yeah, they do work together quite a bit. Burden of proof. So real quick in your mind, what's the burden of proof on civil cases? Okay, give you a little bit of time to think about that. It is what? Nope. It is the preponderance of the evidence. So that just means basically, if I had to put it in percentages, more likely than not, which basically means about 51%. Can you convince me that of your case, whatever it happens to be, whichever side you're on? Can you convince me of that as a judge? Can you convince me that yep, you were right, or your side of the case is correct? That's all civil is. Like it says, preponderance of the evidence. So on the criminal side of things, what do we have? We have beyond reasonable doubt. That is somewhat tricky sometimes because, and this is what gets us into, I'd say, trouble when things aren't explained very well. But the case of it, like, so beyond reasonable doubt is not 51%, it's not 70%. It's saying you are convinced that, as it states there, beyond any reasonable doubt. That doesn't mean anything you can come up with, any type of random hypothesis about what could have happened. Based on the evidence that's presented, could a reasonable person, which is what jurors are supposed to be, or even a judge, depending on the case, is there any reason, a reasonable way to offer some type of doubt or cast doubt onto onto the case. And if not, well, then that means that person would be found guilty of whatever crime they're charged with. But if you can find some reasonable doubt, like I said, the key word is reasonable. That's what gets us into trouble sometimes. People get onto juries, for example, and they're afraid that they don't want to punish someone that didn't do something wrong, which I don't blame them for. But then at the same time, they think, well, I don't want to be responsible, even though this person did it. I don't want to be responsible for, be the one that put them in prison for, say, 25 years. Okay. Well, they said, oh, well, maybe there's a chance, some, like I said, hypothetical, 1 in a billion, chance that would be the case. That's not what they're talking about. They're talking about a reasonable idea. So yeah, I don't want to beat a dead horse, but that's just something to think about. And as far as burden of proof, when it comes to criminal cases, trial cases, it's on the side of the prosecution to bring up enough evidence to prove someone guilty, right? Because for as much as people want to try to, they always make this, they twist it around and say, oh, you're guilty until proven innocent. That's not really how our court system works. 99.99% of all trials or anything like that, it is this whole idea, this presumption of innocence, and it is based all on evidence, and there has to be enough. There has to be enough. In some cases, there has to be enough. We'll get into talking about jury trials in terms of when someone has been indicted, about whether they can even take that to trial, right? We'll talk about that later in the semester. But this presumption of innocence applies to everybody. No one is put in, due to race or sex or ethnicity or any other belief, creed, any aspect of their person. According to our court system and how it is set up, there is a presumption of innocence. So, meaning you have to prove that they were guilty. So, all right. So that's enough about that. It changes a little bit during appellate courts, but that's for trial courts, presumption of innocence. All right. This is something I want to show you. I'm not going to go over every single step in great detail, but this is kind of how a court case starts. Those of you that did had a 145 with me, we did a little debate. Similar concept. You have your opening statement, and this is how I have it set up: is opening statements. Always, the prosecution starts these statements, and then following the prosecution's opening statements, then you have the defense. And this is really important. Opening statement is kind of like setting the tone for the entire case. Doesn't mean it can't be changed or whatever, but it definitely sets the tone. That's why it's important to have a good opening statement, bring forth good evidence, things like that. So, opening statements, prosecution brings evidence forward against the defendant, and then you have cross-examination of witnesses. Redirect simply means now the defense gets to respond. They get to ask, they get to cross-examine that particular witness or expert, whatever the case is. And once they do that, then they can also bring forward a witness of their own. Or if the defendant wants to talk, if they want to, I guess you want to say talk. If they want to get in court and be questioned, they can. We'll talk about that in a little bit as far as how that affects things. But nonetheless, it goes back and forth, rebuttal after rebuttal. But nonetheless, final motions, closing arguments. Judge gives the instructions to the juror if it's a jury trial. And there's deliberation, where they look at the evidence, discuss it amongst themselves, decide what the verdict will be. And once they decide what that verdict will be, then there's going to be sentencing that typically occurs at a later date. And then there can be appeals, which leads to the appellate court system. We will get into that later. But if you ever need to look at this, ask questions, feel free to. Like I said, whether it be email, you can ask me questions, or just in person when we finally get to have class in person, you can ask questions. So moving forward, like I said, opening statements, I already kind of told you what it was. Overall summary, definitely important because it has an affect, meaning like an emotional effect on jurors, sets the tone. Okay. And then prosecution goes, they have their statement. Like I said, they're the ones that open it up. And it's really important for the prosecution or prosecuting attorney to be able to state their case clearly and bring forth, not show evidence during the opening statement, but discuss how they plan to prove that that particular individual is guilty of the crime that they've been charged with. And then you have, so the different types of evidence that will be brought forth during the trial be summed up here with different types of evidence. There were a couple that I chose not to write down because I didn't feel like they were different enough to really worry about, or they were part of something else, so it really wasn't, sorry, I was checking my time. So it really wasn't necessary to put their own thing. But direct evidence is something that proves a fact. As you can see, it's a testimony by a witness, and they're under oath, so anything they say, unless they want to perjure themselves, in essence, lie in court, be charged with perjury, anything that someone who was there in first person, then that's going to be considered direct evidence. Okay, usually through statements, but like I said, testimony by an actual witness, someone who saw it firsthand. Right? Circumstantial evidence is that anything that indirectly proves that someone would have committed the crime, such as you see this listed here, motives or alibi. Based on if we were able to locate, they were sending out text messages on their phone, and it happened to be in the area of where the crime took place. That's circumstantial evidence to say, well, based on where their phone was and what tower it connected to send out that message or make that phone call, says they were in the area. So that seems to match the idea that they would have committed that crime. Okay. Real evidence is anything that's tangible and can be sensed. It's almost like we talk about when we talk about probable cause, using your senses. This is kind of like how it applies to court, is what tangible evidence do we have that is a real tangible item that can be brought to court, like a weapon, documents. It can be, as you see there, DNA, lab results for anything else. It can be pictures of the crime scene itself. Okay, those are real items you can see and look at. If it's those are seeing and hearing. If it's a recorded statement someone made, if it was a just a recording of anything that happened on, like say they recorded on the phone or something like that, those are all things that are considered real evidence or tangible. Okay. Testimonial, that's pretty self-explanatory. Anything that someone says under oath in court. So yes, there is sometimes direct. Testimonial can be direct, but doesn't always have to be. Okay, and then demonstrative, meaning there's drawings, computer depictions, or recreations that you can use to demonstrate a point. And move that out of the way so you can see it better. But yeah, like I said, anything that can be used to demonstrate a point. Sometimes people will act it out, but a lot of times it's more so drawings, or you'll see a chart, or the one thing you're seeing a little bit more often is a computer recreation, especially if the scene has been scanned. So that's something else to look at or consider. The defense, I'm going to try to wrap this up real quick. The defense main concern is establishing reasonable doubt. You don't have to prove anything. You just have to put enough of a seed of doubt into the jury's mind, collective mind, in essence, right? So it could be denying the evidence, like, oh, that's it's either not true, or that doesn't prove that just because there's a fingerprint on a gun that was fired doesn't mean that my defendant, or it doesn't mean that the defendant was the one who fired it and actually when it actually shot someone. He or she may have um, been holding the gun previously, but that doesn't mean that they were holding the gun at the time of the crime, for example. You could use, like I said, challenge prosecution's evidence, which some of these kind of go hand in hand. Um, the other one is what we call an affirmative defense, meaning you supply your own theory or your own evidence proving that someone else did it, whether it be someone entirely unrelated to the case, someone who claims to be a victim, but they actually were the in essence aggressor. Okay, that's kind of what we're talking about with affirmative defenses. And yes, you can use an alibi. You can use this idea. These are like these defenses that we'll talk about later in the semester. Alibi, self-defense, duress, or just simply put up someone else that, or list out your explanation why someone else actually did that. And like I said, one big thing I want to throw out there is that a defendant, if you're charged for something, you don't have to testify. It's part of your Fifth Amendment right. However, once you agree to testify in court, you've waived your Fifth Amendment right. It's no longer relevant. So there's also something I hope this time doesn't cause a problem, but there's an interesting twist with Dominion, the people who had the or the company, which is a whole bunch of dirty stuff with that. But there's that company that dealt with all the elections for a presidential election and even some of the local elections, like state elections, things like that. But the manufacturers of those voting machines hasn't allowed anybody to see mess with the actual, if you want to call them, computers that are inside of some of those. However, if they open up a case against Trump and Giuliani, which they had talked about doing for defamatory purposes, whatever, if they do that, due to discovery rules, which means evidence on both sides have to be shared with both sides, both defense and prosecuting sides, they would have to share all the information from their computers or from their voting machines, in essence, you want to call it that. So it's that interesting twist of, do we really want to go after this person or these people if we have to give up our information that may very well be criminal in and of itself? So that's just something interesting. I'm going to stop here and I'll pick up later. I'm honestly not sure if it'll be part 4 or what it will be. But anyway, we'll talk about judges later. But this kind of gets us started on the adversarial system we have in the U.S. See you later.